All right. Good morning, everyone. Welcome to another Zoom OA session of the 5th District Court of Appeal. It is Thursday, February 23, 2023. I am Chief Judge Brian Lambert. I'll be presiding over this OA case. On the panel with me are Judge Rand Wallace and Judge Adrian Soud, one of our new judges who just joined the court on the from January 1 forward, so it's about 2 months in. So welcome him aboard. We have the one remaining case today, the 10 o'clock case. It's case number 23-31, Dodd Chiropractic Clinic, PA, and is it Eifert and Associates, PA, v. USAA Casualty Insurance Company. You see the clock, counsel, and it's up in my upper left-hand corner on my screen. Each side will have 20 minutes to argue. Appellant, we have set aside 5 minutes for rebuttal. If you want a different amount of time, let me know, and the marshal will adjust that on the clock accordingly. When you see you are going into your rebuttal time, the yellow light will begin flashing. If you want to continue on past that, that's certainly your prerogative. You have an aggregate of 20 minutes, though. So the more of your rebuttal time you use initially, the less you'll have to rebut after the appellee's counsel makes his argument. Remember, we are being live streamed on YouTube, so theoretically people are watching this or can watch this or can watch it later if they have nothing else in their world to do. So you keep in mind when you make your arguments that people can be watching you. So also, if you happen to have any type of electronic device on, please either turn that off or into the mute position so that it does not inadvertently go off or intentionally go off during the course of the argument that distracts either you or your opposing counsel or the court. Okay, that's all my preliminary stuff. So is it Mr. Morris, you're arguing on behalf of the appellants? Is that true?
Yes, Your Honor.
All right, counsel, if you're ready to proceed, you may go.
Good morning, Your Honors, and may it please the court. This is Robert Morris. I represent the appellants in this matter, and I would actually like to request about 8 minutes, just a little bit longer for rebuttal. So this is fundamentally a case awarding 57-105 sanctions to USAA. We have taken exception to several issues that occurred, and as well as the 2 orders that issued on this. We have outlined through the briefs essentially 3 primary forms of relief that we are asking this court to grant. The first is, of course, reversal of the entitlement order outright. That would be under the authority of Lago v. Kane and under the prior opinion of this court in Moore v. Estate of Albany. Now, if the court is inclined or not inclined to grant that relief, we would ask that in lieu of that, a zero award be entered.
Counsel, what did we say in Moore that was, and I hesitate to say that because I think I wrote it, but what did we say?
Moore held that a 57-105 motion or sanctions upon a 57-105 motion must be strictly predicated on what the motion requests and the basis for that motion. If a party is to deviate from what is raised in the original motion, a new 57-105 motion must be served and a new 21-day safe harbor granted. Lago v. Kane
that seems to make sense. But isn't the position that the appellee or USAA took below is that you were paid in full before you filed and therefore you shouldn't have filed, and we told you that in our 21-day safe harbor letter, yet you proceeded forward and we won, so we would like to, and they successfully obtained sanction fees against the firm and the client.
I'll state this clearly because it is critical. Dodd was not paid in full at any time material during the 57-105 safe harbor or from the outset of the case. Now, the facts of the case changed a bit as they do in litigation. As the litigation proceeds, we're able to narrow down and whittle away at the issues. This case was initially filed because USAA misapplied the deductible. And at the time, that was an issue that was hotly debated across the state. Ultimately, the Supreme Court found in Progressive Select that what USAA did in this matter and let me rephrase that. Progressive Select has nothing to do with this case, but the way that USAA adjusted the claim in this particular instance violated that ultimate opinion. Basically, what they did.
Mr. Morris, what do you believe? What does your client believe they are owed, and for what date of service and billing code?
As a matter of right, my client is entitled to $7.87. That would be on the GO 283 code, which was part of the initial bills they received. What happened was that USAA adjusted the claim before applying the deductible. And by adjusting it, what I mean to say is that they struck through one of those codes. They believed one of them was duplicative, or that it shouldn't have been billed twice. Ultimately, though, that's incorrect. What they have to do under Progressive Select is to take the entirety of the plaintiff's bills, apply the deductible, and then you start making your adjustments. Then you make the Medicaid changes, whatever they're going to do. If they're going to strike through codes, it's at that point that you do it.
So did I hear you correctly that $7.87 is the total amount appellants believe they are owed?
As we sit here today, that is the amount the plaintiffs are still owed, had we not dismissed the case, of course, but that amount is a valid claim. It was a valid lawsuit. Ultimately,
was USAA's determination that the $26 or that the G0283 charge that it believed to be duplicative was determined as properly billed based upon date of service provided and not area of body to which the treatment was provided?
ultimately, respectfully, that doesn't necessarily matter, because these particular bills came in at the front end of all of the bills that were submitted. So they were required to apply, or USAA was required to apply the entirety of the patient's deductible to those bills. And these G codes would have been subsumed by the deductible. Because they didn't do.
Is it then your client's position that USAA is required to apply amounts to deductibles even if improperly billed?
That is the position of the Supreme Court in Progressive Select.
All right.
And also my opinion.
Okay.
For what that's worth. So that is really the linchpin of this case. At the end of the 21-day safe harbor, Dodd conducted the deposition of the USAA representative. And at that point, we learned several things, as did USAA. What Dodd learned was that, and by the admission of the USAA representative, that they late paid that G code. They sent a check directly to Dodd for $26.50. I believe it was about a year and a half late. Now, they were already in possession of our pre-suit demand letter at that time. So at that point, they owed postage, penalty, and interest on this particular code. And once that admission was made in the deposition, and the court would like to look at it, the deposition occurred on August 24th, 2017, and record 459, the defendant admits, or USA admits, that they did not pay postage, penalty, and interest. After that deposition occurred, we then filed a motion for summary judgment on postage, penalty, and interest. That motion was heard. At the hearing, the trial court indicated he was inclined to grant our motion on that issue, but he didn't because of reasons unrelated to the merits, specifically that the judge believed that we didn't specifically plead the exact date that the bill was owed and the exact amount of interest within the complaint. Now, I don't necessarily agree with that ruling, but it's a little irrelevant at this point. We did end up dismissing the lawsuit. However, the merits of the case, the court agreed with. In fact, I would direct the court to record 1341 and orally at 4853 through 4952.
Well, counsel, let me ask you this. At that summary judgment hearing, was there also a competing motion for summary judgment from USAA?
There was, and it was also denied. The court denied both motions.
Well, let me ask. I know there's an order denying. Was it argued at the hearing? USAA argued their motion at the hearing, or?
They did, Your Honor.
Okay, so, and the USAA's position at that hearing was consistent with their safe harbor letter that there's no claim here. They've already been paid in full, so let's get rid of it. The case needs to go.
I believe it varied slightly. I would honestly need to look, which I'm happy to do while Appellee goes to give you an exact answer on that. But I can tell you that both motions were denied outright. And as a result,
they were both heard.
they were
right?
both heard.
And this was after the 57105 motion was filed?
Yes, Your Honor. Yes.
Okay. All right, go ahead.
And so at that point, in order to correct the purported pleading issue, Dodd filed a third amended complaint, which specified the exact code and asked for the same relief. And I would just quickly point out, interest was demanded in the original summary judgment. It was demanded in the complaint. It's been demanded from the outset. It was demanded in the pre-suit demand letter. We are always seeking interest on these bills. So at the time that Dodd amended its complaint for the third time to meet the judge's requirements, USAA then filed its amended answer and affirmative defense, which for the first time added this argument about recoupment and an argument about duplicate billing. And that became the focus of their 57105 motion. At that point, that's all that USAA could argue, mainly because the 57105 wouldn't fly under the facts that were adduced at the deposition of the corporate rep, because they admitted that we were owed money. So recoupment became the new issue. Dodd moved to strike that defense for waiver and estoppel purposes. That also went to hearing. At that hearing, the trial court seemed to be interested in entering a final judgment at that time on a motion to strike. We eventually backed him off of that and said this needs to be set for its own hearing. But at that point, it seemed that the writing was on the wall.
Well, let me ask this, counsel. Subsequent to the summary judgment hearing, eventually, you guys dismissed the case and the sanctions were set. But subsequent to the summary judgment hearing, were there any additional and in the context of a 57105 scenario, were there any additional facts that came to light that would have suggested then that your claim was not supported by any of the, the material facts or the application of the existing law? I'm trying to figure out, the judge denies it initially, and then later on, as they're getting ready for another summary judgment hearing, you dismiss the case. Is there something that occurred along the way in that whatever time period? I know it's been a lengthy case, but during that time period that came up that made it clear that your case had no merit?
I don't agree that the case had no merit.
I didn't say it did. Is there something that came up? I should be more clear when I ask questions. I'm trying to throw the softball to you to tell me.
Well, I do appreciate that.
Well, I mean, if there's facts that came up, and I'm gleaning from your comments, they're not. If there are facts that came up that made your case untenable, then that seemed to strengthen the 57105 argument. If there's nothing changed from the denial of the first summary judgment to the getting ready for the second summary judgment, I don't understand how it became a sanctionable case.
What happened, what arose.
Yeah, I assume you'd agree with. That was another ball here I threw to you, but.
Right. And the only thing that arose at that point was a dispute about some X-ray codes. USAA contends that they shouldn't have paid one, and they did pay both. We contend that both were compensable, and both parties had record evidence to support their positions. Specifically, Dodd had the affidavit of Dr. April Dodd attesting to that, the deposition of April Dodd, and the requests for remissions that came in. All are on the record. And all of that testimony from Dr. Dodd was that all of these bills are properly compensable, they're reasonable, related, medically necessary. And as a result, that was the gist. Now, USAA has indicated that they believe that one of those shouldn't have been paid. And they believe that as a result, they overpaid. That's a dispute. And that's also on point and something for the court to consider, because numerous cases, as referred to throughout the brief, state that when there is a disputed issue of fact, and both parties here have a disputed issue of fact with evidence to support their positions, sanctions are not appropriate. 57105 sanctions are not appropriate in that circumstance. So what we're left with, regardless of that dispute, which was actually a jury question, it's going to go to the believability of the two witnesses, their coding expert and our doctor. The court ended up entering an order which resolved those facts on its own and did not account for any of Dodd's evidence that I just recited to you all. Those three issues are valid evidence that the court simply didn't address, didn't acknowledge, didn't explain why he didn't seem to worry about them or why it wasn't an issue. So that's really the only difference that arose after the 21-day safe harbor. But setting all that aside, we were still owed the $787. That never changed. As a matter of right, we have that ability, and we, excuse me.
So let me ask you, at the
that was owed as a matter of right.
At the time of your demand letter, and I guess within 30 days or so, the USAA sent their final payment of $26.50. But at the time of your demand letter, I think it was in August of 2013, or how much was owed, according to your client?
There was a range because it was very difficult to ascertain what exactly USAA had done with the adjustments. Some of their
But what were you demanding?
benefits,
I mean, you didn't just say a demand letter saying, here, I demand that you owe me something and we'll figure it out later.
no, there was a specific amount, and I don't have it at my fingertips right now. I can provide that shortly. But and it's attached to every complaint that's been filed. It must be attached to every complaint.
I mean, if I understand,
what I will do is take a brief look.
Counsel, if I understand your opponent's position is Dodd billed X. There's a $500 deductible. Dodd was the only provider of services to this injured patient. And so whatever Dodd billed minus the deductible equals, this is what Dodd would have been owed on the best days. And we actually paid $5.40 more. And therefore, that's why this case should have never been forward. Is that your understanding in the context of the 57105 sanction order, is their position?
There are issues with how they calculated, specifically in that motion. They've accounted for interest as well as benefits. However, if we could revisit this on rebuttal, I would appreciate it, and I'll pull that information for you as well.
Okay. All right. Very well. You had 522 in rebuttal. All right, Mr. Dutton, whenever you're ready, sir, go ahead.
Judge Lambert, thank you so much. My name is Scott Dutton, and I'm here to represent USAA Casualty Insurance Company in this appeal as the appellee. And the court's covered a lot of things which are very, very important. But let me start with the last one that you mentioned, Judge Lambert, and that is this: that the total amount billed at that point in time, and I have the pre-suit demand letter in front of me. It's page 6 of the record, I believe, but it says total amount billed $788. So if you follow parent and you back out the $500 from that, you're going to get to $288. At that point in time, USAA had already paid $293. So if you subtract the remainder of $288 from the $293, you're right on. That's where you get to the $5.40, excusing everything else, not even looking at everything else, in overpayment. And when they keep talking about, and Judge Howard, I believe you asked the question, but what CPT code, what date of service, what is it actually at issue? And that's where you got the $7 something issue. They're already telling you that we paid that back in, and I have the date written down. Allow me one moment. We had already paid that, and that's what they're trying to build the interest, penalty, and postage model off of. And so that wasn't open or in dispute. The other one that was open, or if you will, in dispute, is an X-ray, which is 72050, which we not only paid once at $107.70, we paid it twice by accident. So you can't bill twice for an X-ray. You can only bill once.
Am I recalling correctly that the payment amount of $107.70 was not related to the deductible, but was related to the permissible statutory adjustment?
That's absolutely 100% correct. And what's interesting is he keeps talking about where and how the deductible was applied. And what he's telling you is erroneous. And that's borne out by the explanations of benefits that are actually attached to the back of the pre-suit demand. And again, you can find those at page 9, 10, 11, 12, 13, 14 of the record. And what they're going to show you is that each and every instance, and we point this out in our brief, they don't contradict it because they can't. And that is in every instance when there was a charge from the plaintiff, and I can go through the charges, the timeline, that 100% of the plaintiff's charges, not the reduced amount, was applied to the deductible, except when it came down to the point that there was, if you will, a remainder. So when you apply the $500 deductible and you do the math, it comes out with a remainder. And if you look at parent actually tells you how that's to be calculated. And so it's only when you get down to the remainder that that remainder is subject to the applicable fee schedules as a limitation on reimbursement, which was what was done. And every bit of that is in this record. And that's the problem. They had the explanations of benefits. They had these explanations of review. They had them. So let me tell you what this all comes down to is, so they can't argue that 720550 is in dispute. That's the X-ray, because it was paid at the fee schedule, as you asked, Judge Sullivan. It was paid at the fee schedule, but it was actually by mistake that it was paid twice. And the reason it was paid by mistake is because they billed us for the 70250. They billed us that on May 2nd, 2026, and it was paid at the fee schedule. They then billed it again on June 20th. And at that time, instead of USAA saying that it was a duplicate billing, they say it was untimely. They bill it again on September 17th, and USAA mistakenly pays it then for the, no, they bill it again. And then lastly, on November 2nd of 2016, they bill it again. They billed it 4 times. And it is on that November date that they paid it again for the second time. So they received for a bill that was paid and should have been paid at $107.70. They actually get paid a total of $215.40. But even with that, so if you back out, they don't even talk about backing out the overpayment from what he told you today is $7-something. They're just not even going to acknowledge that. The appellants are going to ignore that overpayment.
Counsel, let me follow up what I was asking Mr. Morris and ask you for the same thing.
Please do, Your Honor.
So you agree that there was a hearing where there was competing motions for summary judgment noticed for hearing, and that there's an order entered by the trial judge after that hearing denying both motions. Was your motion heard? Was it argued?
The answer is yes, no. The court considered it, but what it said is that based upon, at the summary judgment standard, based upon what it had before the court at that time, that it didn't have sufficient satisfaction in its mind of settling what was paid, when it was paid, and so on and so forth.
Well, that kind of goes to my question then. So your position as to why you were entitled or properly awarded sanction under 57105 is that this is pretty clear. They billed X minus the deductible. We overpaid it by $5.50. Case closed, should never have been brought. That would seem to be a fairly straightforward argument to be made at the summary judgment hearing. And I assume that would be an argument you would have had to have made vis-a-vis why we're here today under the 57105 scenario. If the trial judge then thought that there was not enough to grant summary judgment and there was no difference in any additional facts that came up subsequent to the summary judgment prior to the notice of voluntary dismissal being filed by your opponent, how is this that this falls under the 57105 sanction event? And I understand that it's been loosened since when it first started long ago when we were younger, that it had to be frivolous from the inception. Now it's just, at any time when it was presented to the court or any time before trial, the claim is not supported by material facts. why, well, if you deny a summary judgment, how does that then turn into a 57-105 scenario, absent some additional facts coming to play that make it abundantly clear that the plaintiff's case is not supported by the material facts necessary to prove it?
It tracks what it did today with with the appellant's argument. And that is that they, if you will, paper-wise, tried to raise an issue that was inaccurate factually, was misleading to the court. And so therefore the court wanted more clarification. So let me give you time.
I don't understand how it would be. I mean, your case for the 57 and clarified for me, then your case seems to be, let's make it even easier, round numbers. Dodd bills $2,000. We have a $500 for all. That's the highest. That's the bill for all services. No deduction. No, whatever. And there's a $500 deductible. So 2,000 minus 500 is $1,500. USAA pays $1,505. So I come to the summary judgment hearing and say, Judge, look, forget about the fee schedules or whatever. Let's just take the total bill minus deductible, which is undisputed, minus what we've paid, which is undisputed. We have overpaid by $5.40. Case over. They have no damages. Summary judgment should be entered. And it would seem a trial judge would then look to Mr. Morris and say, well, that makes sense to me. I don't have to get into coding world and all this. How come you don't lose? But apparently the trial judge wasn't convinced, and that seems to become problematic, or you need to convince me why that's not problematic here.
If you allow me to digress for just 1 minute in order to answer your question, because you have to look at what the timing was at the time. The motions for summary judgment and the timing of the motion for sanctions, it occurred when the deposition of the corporate and backing into when the motion for sanctions was filed. If you look at when the corporate representative was taken and when the 57-105 was taken, there was not at that time, for purpose of a summary judgment, a sufficient record made of explaining in the record what had occurred regarding the charges. In other words,
but that's your side, though. I mean, that's what I'm not getting from your side. I mean, you guys, we've got a total number of bills of X. You guys know what you paid. You all know what the deductible. I mean, that how does it? Well, we're not clear about our position until we get deposed. That's what I'm hearing you say. So you need to clarify that for me as well.
No, we're clear, and obviously we're looking at the defendant through this lens and not what the plaintiff knew or should have known at the time, because we're here on the plaintiff's failure to dismiss a case that was paid, not only paid in full, but overpaid for its services.
I know, but that's what you wanted to win in front of the judge on a summary judgment hearing on a motion that was filed after your 57-105 sanctions, where you gave him the 21-day safe harbor, and you guys were very clear and succinct in your safe harbor letter saying, we've overpaid you by $5. Please dismiss the case immediately, I think was the term used in the safe harbor letter. So at that point, when they don't do it, you guys can say, well, hey, this is an easy peasy summary judgment motion, X minus Y equals Z. We've paid over by too much, and we can walk into the trial judge, and trial judges don't have to have this great knowledge of coding and et cetera. The A minus B equals C. We're out of here. And that apparently didn't carry the day.
Well, and so here it is, Judge. Again, when we went and filed that motion for summary judgment, as you point out, paid in full, we're traveling on the simple math problem. And this is all about a math problem of the $788 minus $500 minus what we paid, which at the time include the double payment of the x-ray and also the payment of a second unit of the GO283, which is E-stem. That really wasn't the sum and substance of what it was about. Now the plaintiff knew it, but at the time we're going there, we're going before the court and we're saying we've overpaid this. And the plaintiff in turn is arguing that oh no, you didn't properly pay these because of the deductible issue. You didn't properly pay these because and misapplied the deductible. You didn't properly pay these because there's still the charge of the second X-ray, and you mishandled the GO 283, similar to what you've heard today.
Well,
The summary
I
judge.
understand though. I mean, let's get big picture about what you're asking us to do. You
Yes,
want, in a scenario we have is saying, okay, let's assume we write an opinion affirming the what the trial court did. And we write and we talk about the history of the case, the limited history of the case, and just say, we have summary judgments that were argued and denied. There was no material change in the facts from that point forward until the notice of voluntary dismissal was filed. Yet, despite the denial of summary judgment, 57-105 fees are appropriate. That seems to be a real slippery slope, walking off the ledge scenario we have here. Tell me why that isn't that way.
Judge, and again, I'm tracking with your argument and understanding it because it has to do with summary judgment evidence at that point in time.
But it's your evidence. I mean, whatever they say, you have their bill. The bill, use my $2,000 number, saying, Judge, we got $2,000 total bill from this guy. No ifs, ands, or buts about Dr. Dodd. We have an insurance policy that says a $500 deductible. No ifs, ands, or buts. We were the only care provider, so it wasn't like we're applying the deductible to a hospital or whatever. So that's not an issue. We know we've paid this total amount. If you add all those things up, we've overpaid by $5. Case should be over. We win. I prepared a summary judgment for you to consider. What else is there to do? I guess I won't talk anymore. I've laid it out saying I don't understand.
No, I understand.
I don't understand how this turns out this way. So you got 5 minutes and 18 seconds to do your best.
Yeah, I understand, Judge Lambert, and I understand why you're asking the question. And again, it has to do with what the scope of the picture of what the judge was reviewing under the summary judgment standard at the time. Now, I do want to tell you that when this case was dismissed, we refiled the motion for summary judgment with no material difference in the facts at all. It only brought out the things that I've talked about today. That is
Mr. Dutton, I'm sorry to interrupt you. I'm trying to give you time certainly to answer the chief's question, but I want to piggyback his question. If I recall your brief correctly, you seem to indicate that the majority of the time before Judge Floyd,
Yes.
at the time both motions for summary judgment were heard, that yours was not heard. And please correct me if I misperceived your briefing, but that your motion was not heard and that primarily all argument was directed toward Dodd's motion for summary judgment. Did I misperceive it?
No, sir. In fact, I thought that's where I start with my answer to Judge Lambert, that when it came down to it, it was basically a paper motion that was before the court. And without our opportunity to explain the things that we're explaining today, and essentially if you will, all the oxygen in the room was taken up by Dodd and not given us to like Judge Lambert's doing today to explain what was there. And
Okay,
basically,
well, all right. Well, let me follow up on that, and I can give you more time if you need it, if I think you need it. All right, so you're here. There were no issues that it was noticed. Both were supposed to be heard, and I understand we were all trial judges before the panel, so sometimes hearings get away from you, and all of a sudden we're focusing on one, and then we look up and the clock's run, and there's people waiting for us. So you then get an order saying, oh, by the way, you lose 2 on your summary judgment motion. You file anything saying, Judge, not for nothing, we really didn't get a chance to argue it. Can we have a rehearing or a reconsideration of this?
we didn't at that time, but yes and no. That's what we ended up. That's what we ended up with the second motion for summary judgment, essentially based upon the same facts, but enhanced in clarity and enhanced in explanation. So with all due respect, and I know the courts are busy and certainly don't have time to do our work for us looking at the transcripts, but following up with what Judge Saud said, if you read the transcript, you'll see that we do not have an opportunity, and that's why we put it in the briefing, to fully and completely argue our motion. Basically, the judge is looking at that, our arguments against the plaintiff's motion, and saying, I'm just denying the motions for now. Now, you're right, we could have gone back in a motion for rehearing, but instead what we did was refile the motion for summary judgment, which was what occurred just prior to the dismissal in this case, that it was coming up for hearing.
Mr. Dodd, if my notes are correct, the clinic's motion for summary judgment was filed January 19 of 2018, followed by USAA's motion for summary judgment March 8 of 2018, which was 20 days before the motion for sanctions under 57105 was actually filed on March the 28th. I do not recall the date of Judge Floyd's order denying the motions for summary judgment, but am I correct that USAA filed a renewed motion for summary judgment August 6th of 2019, approximately 4+ months after the initial motion was filed, in a shorter period of time after Judge Floyd denied USAA's motion for summary judgment?
Spot on, being accurate. And so this is what the court did. The court issued its order on May 22, 2018, denying the cross motions. And then on my timeline, USAA then comes back on October 9, 2019. As you point out, August 6, 2019, we file our motion for summary judgment, then come
So
back.
that's not 4 months, that's 16 months.
Yes, sir, a year and 4 months.
All right.
But that's spot on. That's exactly what we did. And so we came back with it and pointed out that what we did in opposition to Dodd's motion was now being clarified and had been clarified as a matter of the record. And the court undoubtedly would have, based upon no additional facts, no additional circumstances, would have had to grant motion for summary judgment on behalf of USAA, because now the record was crystal clear that before the pre-suit demand was served, before the suit was filed, that the plaintiff had been overpaid. We just tried to keep it obviously too simple when we made the initial argument. And then
so let me ask this question then. And so certainly it appears that I misspoke as it pertains to 4 months to a year and 4 months. If it's renewed later because it had quote unquote become crystal clear, does that suggest it was not crystal clear prior to that particular time frame?
It was always clear. And again, let me put this under framework, and I see my time is up, if I may answer the question, Your Honor.
Chief?
Go ahead. I'm sorry, Your Honor. It wasn't coming across to me that it was clear. And it was, but it was crystal clear to the plaintiff because they knew they had been paid twice for the X-ray. And they also knew they had been paid for 2 units. And they knew it before the suit was filed, that they had an overpayment well in excess of certainly the $7 that Mr. Morris or the appellants tell you today that they're entitled to. But Your Honor, thank you for the additional time in pointing that out. Well, we request the court to affirm that this case never should have been in litigation for this entire time, because the appellant knew or should have known from the very beginning that it had been overpaid. Thank you, Your Honor.
All right. Thank you, counsel.
Thank you.
All right.
Your
Mr.
Honors, I need
Go ahead.
to be very clear about something, Your Honors. Dodd was not overpaid. They were not overpaid based on the calculation in the 57105 motion, because by the admission of USAA, they owed $7.87.
Well, let me
Even
ask.
accounting for.
Let me ask. Going back to when you send the demand letter and you give them the whatever the 30 days. So within that period of time, if USAA calls you up the next day and says, "Okay, how much money do you need from us to end this? How much to satisfy your demand letter? What's the number?"
At that point, we demanded $736.35. What it ultimately came down to was that we were owed $26.50. After that point, it became apparent that they had issued a late check for $26.50. All of this coming out at the deposition. But in any event, $7.87 was still owed. And I think we've gone a bit off track. Most of what the court has just heard for the past 20 minutes is smokescreen and more subtle argument about recoupment. I need to remind the court that recoupment, overpayment, X-ray codes, none of that is in the only 57105 file in this case. The only motion.
Recoupment's a defense. Recoupment's a defense, correct?
It was a defense after the 57105 was filed and served.
Understood, but recoupment is premised upon a determination that your clients in fact owed money, correct? It's akin to set off in the same transaction.
It's quite different to set off, to be honest, Your Honor. Set off is
from the same transaction, if I'm understanding correctly.
No, they have lumped recoupment in by way of these two X-ray codes. They're claiming still, which is disputed, that they shouldn't have paid one of them. Dodd's position is that they should have paid both of them. The amounts at issue, that's a jury question, or not the amounts at issue, forgive me. Whether or not that bill, that X-ray code, one of them was duplicative, that would have been a jury question. But that is not what we're here on, Your Honor. That is not what we have ever been here on. It is strictly limited to that motion for sanctions. All of this recoupment and X-ray codes and everything you just heard for 20 minutes all came about upon the third affirmative defense and after the 57105 safe harbor had run. So
Well, I guess
Lago v. Kane.
Just following up what the judge was saying, or whatever you want to call it, their position from the get-go, you know, whether they paid it erroneously, mistakenly, whatever, they say we paid you too much. We overpaid you, and that's why the case should go away. Whether they want to call it as recoupment defense or what have you. I mean, that's the purpose of the 57105 motion. Well, let me follow up. I want to, and I do recognize in the brief, the answer brief, that they were saying we didn't get a chance to argue our motion for summary judgment at the hearing that I've been referring to when you were arguing initially. What's your response to that?
What they primarily argued at that hearing was the issues with the complaint. That's where Judge Floyd got that information from, that wasn't specified as to what date of service or code or the amount of interest. That was the reason our motion for summary judgment was denied. Ultimately, though, it's another smokescreen, Your Honor. At the end of the day, at the time of the expiry of the 21 days, Dodd was owed money. That is a valid lawsuit. And if you take the calculation, which is in the motion for sanctions, which they don't mention overpayment or a credit or anything in that motion, it must be strictly construed against them. It's $5.40. They still owed us, by admission, $7.87. So now we're talking $2 on the defendant's best day. And frankly, $2 is still a valid case. It may not seem like a lot, but it's a valid legal case.
So
in other
words, if at the end you're saying you could have brought suit for $2.57 and that should be considered in a trial court. Is that what you're saying?
I'm saying it's a valid claim.
I'll rephrase it. That sounds like that's what I hear you saying. And that go ahead. There's smart cases out of the fourth DCA that sometimes we get to a de minimis amount, which makes utter sense.
Well, I would point out to the court the recent case of Baker Family Chiropractic. This came out a couple of weeks ago. I believe it's still up on rehearing, where the court disagreed with that fourth district case. And even under the fourth district case, that was largely towards attorney's fees. But interest since the inception of PIP litigation, postage, penalty, and interest is lumped into the claim for benefits. It is a viable cause of action. We had a viable cause of action at the time that 57105 came due. And as a result, the court need look no further to anything else. None of the argument regarding the X-ray codes. That's all quite irrelevant, respectfully to Mr. Dutton, but it's irrelevant, Your Honor. The end of the day, we were owed money at the time that 57105 expired, and the court needs look no further than that. And what we would ask you to do is to reverse the entitlement order. If not that, then we would ask the court to enter a zero award for the defendant's failure to carry its burden of proof at the fee hearing. And in alternative to that, we would ask the court to enter Dodd's fee experts line item reductions and commentary as to the amount owed. We didn't get to talk about that, but that is the relief we're seeking. And I thank the court for its time today.
All right. Thank you, counsel. All right. We'll stand adjourned.
Your Honors, thank you so much.
You bet.
Thank you, judges.